During the last 50 years, while most New Zealanders were busy working to build a prosperous nation, a toxic radical ideology has slowly been creeping into our public service, our legal system, and among our so-called intellectuals in academia. Those that are infected with this ideology believe that white people, their way of life, their institutions of state, and their penchant for building peaceful and prosperous nations is inherently evil and should be abolished. They call this abolition decolonisation. They are the traitors among us. They work quietly in the background to acquire positions of power and influence, from which they plot our incremental downfall and demise. The office of the Solicitor General of New Zealand is a powerful constitutional position. The role requires an unwavering commitment to upholding the Crown's sovereign authority and ensuring the government operates within our constitutional framework. Appointment to the office is made by the Governor-General, reflecting its direct relationship to the Crown rather than to the elected government. That's an important point which I'll return to shortly. The Solicitor General is the head of the Crown Law Office, which is the Crown's own exclusive law firm, so she or he has oversight of the Crown's fleet of lawyers. If you've not already seen or heard who is, at least for the time being, our Solicitor General, let me introduce Una Jagos. Jagos started as a Crown lawyer over 20 years ago back in 2002. She spent a year away at the GCSB from 2015 and returned to Crown Law as Solicitor General in 2016. During her tenure at Crown Law, Jagos was heavily involved in conducting lawfare against children who were victims of the government-sponsored Lake Alice Child and Adolescent Detention Centre. At Lake Alice, children were routinely punished with electroconvulsive devices and anti-convulsion drugs such as formaldehyde. They were also physically and sexually assaulted. They were terrorised psychologically with the ever-present threat of punishment for the slightest infraction. These punishments and abuses caused intense pain, narcotisation, memory loss, post-traumatic stress disorder, muscle rigidity, and psychological distress. The United Nations determined that these children had been subjected to torture. Many of the victims had permanently and irredeemably shattered lives as a result of the inhumane treatment they endured at the hands of their abusers, Dr. Selwyn Leeks and his accomplices. Lake Alice's notorious Villa 11 is the 1970s version of Belsen or Auschwitz for the children who endured and survived its atrocities. It is surely New Zealand's darkest hour for the dehumanisation of vulnerable and innocent children. Subsequently, the Royal Commission into Abuse and State Care highlighted Crown Law's aggressive legal strategies in dealing with redress for the victims of Lake Alice. This included invoking the statute of limitations, withdrawing legal aid funding, and withholding crucial documents. The Royal Commission condemned the use of significant resources to deny survivors their voice and defend what the Commission referred to as the indefensible. Jagos's involvement in specific cases has drawn particular scrutiny. In the case of Lake Alice torture victim Leonie McEnroe, Crown Law under Jagos's leadership fought the claim for years and withheld vital documents from the police. Similarly, in the landmark Stephen Watt case, Jagos's Crown Law spent $90,000 on private investigators and pursued re-traumatising lines of questioning during the trial. Jagos's handling of Keith Whippen's case involving abuse at a Puni boys' home has also been criticised. Internal emails revealed encouragement by Jagos to use psychological warfare on victims as a strategy to stifle their claims. If it's not already clear, Jagos's modus operandi towards the victims of torture at Lake Alice is completely and utterly unacceptable. That's strike one. In October 2024, Jagos published an update to the Crown's prosecution guidelines. These guidelines are used by government agencies, primarily the New Zealand Police. They provide guidance on decisions about whether or not to prosecute criminal offences. The prosecution of criminal offences is founded on two overarching principles. The first is that there's sufficiency of evidence, in other words, probable cause. That's a straightforward objective test concerning the evidence. The second test is what is known as the public interest test. The public interest test is subjective. This is where things get fuzzy. Subjective tests are vulnerable to ideological persuasion, and this vulnerability in public prosecutions has two levels. The lower level is the subjective opinion of the particular police officer or prosecutor turning their mind to the question, but the higher level is the explicit instructions in Jagosa's Crown Prosecution Guidelines about what factors to take into account. Let's put it like this. At the lower level, the prosecutor's discretion is about how to take those factors into account. So, for example, Jagos might say, think about the cost of prosecuting an offence. Then a prosecutor thinking about the cost has the discretion to judge whether the cost is too high to bother prosecuting or low enough to justify the expenditure of taxpayer funds. In her first attempt to promulgate Crown Prosecution Guidelines, Jagos instructed that prosecutors take into account the racial ancestry of the offender and/or the victim. In other words, think carefully before prosecuting Māori people, but don't apply that same thought process or care to other people. Significantly, Judith Collins, the Attorney General, refused to endorse the guidelines, and Jagos was forced to withdraw them. The racially based virtue signalling instructions that Jagos thought were appropriate were the antithesis of everything we the people mandated at the last election. They were contrary to the direction of the coalition government and a comprehensive failure to read the room. That's strike two. Jagos has now reissued her updated prosecution guidelines, and this time she's advised prosecutors to learn tikanga and Māori language. She just seems mentally incapable of refraining from ideological racial virtue signalling. She then did an interview with journalist Sean Plunkett and was questioned about why her guidance, which is guidance over the single question of whether or not to prosecute a criminal offender, included references to tikanga and Māori language. Tikanga has been specifically rejected by the High Court of New Zealand as a defence to a criminal charge. In respect of tikanga, she insisted that it is part of New Zealand law and cited the Oranga Tamariki Act. However, the Act does not make any mention of tikanga in regard to prosecutorial decisions. In fact, it has its own mandated and exhaustive instructions on prosecuting minors for criminal offending, and those instructions exclude tikanga. These are statutory instructions enacted by our elected representatives that cannot be overridden by public servants. Jagos's indulgence to tikanga is misconceived taxpayer-funded racial virtue signalling. Jagos also referenced the Māori Language Act as part of the law, but the Māori Language Act makes it clear that the effective recognition of Māori language does not affect the right of any other linguistic community to use the language of that community. This means that any guidance given by Jagos regarding prosecutors learning any languages should have included all languages or none at all. The Māori Language Act has been in force since 1987 and for the last 37 years has never been deemed necessary to include in prosecution guidelines. In fact, the Māori Language Act establishes a Māori Language Commission. That commission is responsible for government oversight of the Māori language. Jagos has no legal authority to usurp the statutory responsibilities of the Māori Language Commission. Her reference to the statutory justification for her promotion of Māori language is again misconceived racial virtue signalling. The worst part of Jagos's compounding failures is that she seems to have taken a page from Prince Andrew's playbook on how to transform an interview into a train wreck. And this is where I return to the rule that the Solicitor General's role requires an unequivocal, unwavering commitment to upholding the Crown's sovereign authority and ensuring the government operates within our constitutional framework. During her interview, Jagos was asked critical questions that she failed to answer, questions which strike at the heart of her fitness to hold office as our King's chief legal advisor. The first question was whether she believed New Zealand needs to be decolonised. In other words, does her ideology support an unwavering commitment to upholding the Crown's sovereign governing authority, or does she believe that the sovereign authority to govern New Zealand should be vested in the leaders of Māori tribes such as John Tamahere and co? Jagos repeatedly refused to confirm her allegiance to the Crown. She also refused to confirm whether she accepted critical race theory. That's the theory that all white people and the structures of their society are inherently racist. Critical race theory is the bedrock of decolonisation ideology. If Jagos's personal ideology does not endorse decolonisation and critical race theory, then there's no valid reason whatsoever for her not to answer the questions put to her. Her failure to denounce that ideology is a betrayal to our King and incompatible with the allegiance to our sovereign crown required by the office over which she presides. The ideology that Jagos refuses to denounce when manifested into violent action amounts to treason, which until as recently as 1961 was punishable by a death sentence. That's strike three. New Zealanders should not sit back and see our country slip into a civil race war because of radical left ideologues in the public service that tacitly support the decomposition of our nation and democratic system of government. A petition to Parliament has been started calling on the House of Representatives to advise the Governor-General to replace Jago's as the Solicitor General. I encourage all New Zealanders who care about our democracy to sign the petition, which you can reach from the link in the description below. I also ask that you share the link to this video among all patriotic New Zealanders who value our democratic way of life. Thanks for watching, take care and have a wonderful Christmas and holiday break. Do take a minute to leave a comment. I appreciate your perspectives on the issues that we face in our young nation state. Please give us a like and be sure to subscribe to be notified of new content as it drops. See you next time.